go into questions. We have 26 questions right now, which is amazing. Okay, question number 1. The association's bylaws afford its board customary powers for the administration of association affairs. The board adopted a format for all association meeting minutes consistent with the criteria framed on the Mulcahy website, how to take perfectly proper meeting minutes. Okay, good. That's in our board member cheat sheet if anybody wants to see that. The board secretary later produces an extensive verbatim transcript of an association meeting and refuses to conform it to the established format for meeting minutes, arguing that only association members can approve the format and content. What is the board of directors' authority and best course of action in this situation? Okay, the board secretary doesn't get it. The board secretary should be creating the minutes and they should be a page. And we should not be doing a transcript like that. That's, it's not advisable, it's not customary, and it's, going to be very confusing to the owners. So what I would recommend is talk to the board secretary, give her a copy of my cheat sheet, board meeting cheat sheet. On the flip side, it has how to take perfectly proper meeting minutes. If the secretary refuses to comply, go to your bylaws. You should be able to remove the secretary by a vote of the board from that person's position as a secretary. They'll still be a director at large, but the secretary needs, it's the most important role of the secretary is taking meeting minutes. And so, or overseeing the taking of the meeting minutes. So if they're not willing to comply with, what's required under the law, they need to be removed as the secretary. Okay, number 2, our board unanimously passed the replacement of our pool fence at the end of 2023. Can the new treasurer in 2024 prevent or delay its installation? The board has been waiting since December for the deposit to be mailed to the fence company, only to find out that the treasurer put a stop to it. Okay, I hate to say this, but this is like the same analysis as the last one. This is totally ultra-virus act by the treasurer. This was passed by the board, majority of the board. The treasurer needs to stop doing this and needs to comply with the wishes of the board. And if they don't, I would recommend that you give the treasurer a warning. The treasurer doesn't, comply and allow the bills of the association to be paid. Look at your bylaws, but the treasurer can be removed typically from an officer position by the board, a majority vote of the board. The treasurer will no longer be the treasurer, but will be a director at large after that, and that's fine. And appoint somebody else to be the treasurer. Okay, next question, number 3. Can spouses both serve on the HOA board at the same time? I guess the underlying question is, why would spouses want to serve on the board at the same time? Okay, I get why. Because there's usually not enough people to run, right? Or nobody's willing to run. And then you say, oh, my husband will come, he'll be our quorum. Okay, so best practices is don't do this because it shifts the balance of power on a board. It probably can be done unless there's a prohibition in your documents. So usually it says that the only qualification to be on the board is to be, an owner of record. And if both spouses are owners of record of one lot, technically they both qualify to be a board member. But it's just not advisable because I said the balance of power. Let's say you have a 3-person board and, 2 of the 3 are spouses. That's a really dangerous situation because, the spouses could be talking about anything at home and they could be making decisions regarding the association. It's just all around a bad situation. I have never seen it work out. So can they? Probably yes. I'd have to look at your documents. Unless there's a prohibition in the documents, they probably can. But is it best practices to do it? Absolutely not. And I do not advise it. Okay, question number 4. The current board passed a new landscape design guideline to plant a specific number of plants and trees. The new guideline is being applied retroactively with homeowners with well-maintained yards, but no trees receiving violations to plant. The original CC&Rs did not require a specific number of plants and trees. Is this legal to apply retroactively? I don't know, probably not. Okay, and like the design, I have to look at the documents, but is it equitable even to make people go and, plant trees like this. And I mean, I don't know, there's probably some history on this. Maybe there were trees on these people's lots and they maybe died due to weather or something. I don't know. But I mean, I think anytime that you're trying to force somebody to do something on their property and it's not in the CCNRs, I think you're really going to have some trouble with that. So something doesn't sound right on that. And I think, you could voluntarily require people to do it if they want. I mean, if they want to, you could say, this is what we want going forward, or if they're redoing their landscaping, this is what we need, going forward. But making people retroactively go back and change their landscaping design to, make them plant a certain number of trees that wasn't originally required in the CCNRs, I think that's overreach. Okay, question 5. We are a small community and there is a large need for repairs in our older complex, including repaving a parking lot, filling off our grass to switch to gravel and update landscaping, change our wood fencing to bricks to avoid continuing replacement of wood fencing, and more. Is it possible for HOAs to seek grants to help with major projects and reduce stress on current funds? Really good question. Yes. Go to the city that you are currently, your association is located in, and talk to their neighborhood services department. Most cities have a grant program for a lot of the things that you're discussing here. So I hope that you will do that. Typically, the grant program resets July 1 because their fiscal year is different than HOAs. So now's a really good time. I mean, you could be the first person in line in July to get grant money. So now's a great time for you to be reaching out to them, finding out more about their grant process. Okay, question number 6. Is there not documentation for ARC committee and or the board approval in members' file? How should the new ARC board handle the situation? Is there a time limitation for the new ARC or board for correcting the situation? Okay, so let's say that so what I'm hearing is that there's not a lot of paperwork that's showing prior actions by, the board or the ARC on a member's file. How do we handle the situation? I think you got to look at it on a case-by-case basis because I'm not sure exactly what you're doing. Are you trying to find out if they have approval for something after the fact and there's nothing in the file? I don't know how to answer this question. Is there a timeline? I mean, I guess what I would say is if a violation has existed for more than 3 years, you're probably waived from enforcing it, would be my short answer. And it just underlies the importance of the board and the architectural committee having really good records to show if something's approved or disapproved by an owner architecturally. Question 7, does the state of Arizona require the owner to be able to cast ballots at the annual meeting? What statute number? So great. My office is amazing. There, you got the statute number in there for me. Thank you. ARS 33-1812, if you're a planned community, is going to be the one that you're going to want to look at. Basically, it says that owners should be allowed to cast a ballot by absentee ballot or in person at a meeting of the members. Now, remember, that's only for decisions that are made at a meeting of the members, like, your annual meeting. This would apply to, or removal of board members meeting, maybe a meeting to vote on a special assessment. That would be the examples where, you would be required, the board would be required to have an owner, either be able to cast a ballot, electronically or in person or by mail or in person. You have to have that in-person element under the law. Okay, question number 8. It looks like we are up to 30 questions now. We have a community Facebook page. If discussion occurs on any community item and board members like the item, or if there's any discussion on the Facebook page, does that constitute action or a quorum? I would say it's really hard for me because I don't know, is there a quorum of board, discussing it on the Facebook page under the comments? Here's what I would say as a better point. The board should not be liking things. The board should not be commenting on things. I mean, maybe the board posts a subject like, oh, we've got our garage sale this weekend. Or if somebody has a question where, where do we find the meeting minutes? The board could say, oh, they're on our website. Click on the meeting minutes tab on our website. but the board shouldn't be going back and forth with owners in any way on any sort of social media. And, there shouldn't be any fighting. There shouldn't be any, none of that. When you're on your board, you are perceived as talking on behalf of the board. So you have to be really careful commenting in public forums like this, when you're walking your dog, when somebody comes up to you. This actually happened to me with our association, where I was out walking a new baby, and somebody asked me to come look at their paint color that they'd painted on the side of their house. And I looked at it, and they asked me if I thought it was pretty. And I said, yeah, it's nice. And they walked away from that conversation thinking that me as a board member had just approved their paint color. And I walked away from that thinking, did I just get schnockered? Like, like this is not what I wanted to have happen here. So after that, I just made a decision. I don't talk about board business when I'm out, walking or running or whatever. I just say, come to the board meeting, and that's the best thing that you can do. Question 9, if the board has a training session or receives reports from staff regarding maintenance issues, is an open meeting required? Yes, it is. So anytime a quorum of the board is meeting to discuss any sort of association business, whether there's votes being taken or not, it is an open meeting. And you need to follow the open meeting law. Question 10, does a discussion about firing a vendor have to be in the open meeting, or can it be in the executive meeting? What about libel issues? So as I said previously, you can discuss, job performance of a vendor during the executive session, and I would recommend that you do that. It's going to be slander, because it'd be spoken if you're talking about a vendor and if somebody's trying to say that you said something false or defamatory about them. Just stick to the facts. This vendor was supposed to come out and trim the trees on Tuesday and they never showed, or, they only trimmed at 10 feet. They should have trimmed at 12 feet. I don't think you have to worry too much about defamation as long as you're telling the truth. But the short answer would be, you should be talking about vendor issues, performance issues in the executive session, in my opinion, and you are allowed to do that under the law. Okay, question 11. I have found that board training is instrumental in guiding general policy. In our case, board training is conducted by our attorney. So the board meets as a quorum and uses legal advice to close the meeting and go into executive session. Is board training the correct use of legal advice to exclude members? Clearly, our board is adopting a policy based upon what they learn in these private closed training sessions. I'm okay with that because, it's all, you're talking to your attorney. That's something that's a protected area under the executive meeting laws. And, I don't think that your board is doing anything that's illegal. They're allowed to do that under the law. Question 12, regarding representation. Should there be a verbal consent with the owner acknowledging the other representation in addition to the written notice? There are people who will write their own letter and will sign the owner's name. Okay, so regarding representation. Okay, so you're talking about the appointing the designated agent, is my understanding of this question. So do you have to have verbal consent from the owner in addition to the written notice? No, the statute just says that the owner signs something saying, I, Beth Mulcahy, give Johnny Appleseed, I make him my designated agent to talk for me on behalf of me at the board meeting, and that's that. I mean, I don't think we can add the verbal consent to it. If you think that they are, falsely, signing something, if you think the designated representative is forging something, you could send that to the owner and say, we're just asking for confirmation that this is in fact, you agree with this. Question 13, my HOA board holds general meetings every 1 to 2 years. Hence, approving the minutes and financials are done every couple years. Annual meetings are held yearly. This is a community of less than 200 units. In the meantime, policies, amendments occur, and homeowners are made aware of these changes by mail. Subsequent meetings are always to be determined. Is this a new practice for the industry? So I guess this is not kind of similar to what my experience is. I mean, I don't know, maybe some associations like in Northern Arizona don't meet as frequently because it's more like vacation homes, but my feeling is that most associations are meeting much more frequently than this. So the practice that you're describing here is not consistent with, the norm in our industry by any means. And really, you've got to review those financials more often so that you make sure that there's not any fraud, theft, or embezzlement going on in your association. Okay, question 14. If two board members are having a discussion about the HOA, does that constitute a board meeting? Or is that why there needs to be a quorum to be a board meeting? Is it still an official board meeting if there is a quorum, but the community manager isn't present? Okay, all good questions. So it depends on how many board members you have in your community. Okay, so if you have a 3-person board, if 2 board members are having a discussion, that's a quorum and you're having a board meeting, right? If it's a 5-person board and 2 board members are meeting and having a discussion, it's not a board meeting because it's not a quorum. Do you have to have a community manager present to have a quorum at a board meeting? No, it's all about the board members. So if you have board members, a board of 5, 3 out of 5 is a quorum, okay? Doesn't matter if the manager is there or not. Question number 15, does the presence of a designated representative count towards meeting the quorum needed to hold the meeting? No, it does not. So we're going back to this designated representative thing, which is interesting. We're getting a lot of questions on that. So like I said in my presentation earlier, the designated representative cannot vote at the annual meeting. They don't count towards quorum. I'll add that here. And even if they have some sort of a power of attorney, it still doesn't count towards a quorum and they still are not allowed to vote. Question 16, can an architectural appeal be made in an executive session? Our CC&Rs say all ARC approval or disapproval are final. There is no violation involved. Let's see. It depends on, how the appeal is being handled. So if we go back and look at the sections in the executive session under 33-1801 and 33-1248, it could fall under, let's see, appeal. So it could be under subsection E, and discussion of a unit owner's appeal of any violation cited or penalty imposed. So, technically an ARC appeal isn't going to be a violation or in violation or penalty yet. So probably that needs to be done in the open session would be my take on it. If let's say sometimes what happens on these architectural things is somebody changes their windows, right? And they're in violation, and then they go back after the fact and then submit an architectural, in that case, then you could do it in executive session because there's an underlying violation. But generally speaking, the way you worded this question, no, an ARC appeal shouldn't be done in executive session if there's no underlying violation. And you put in there no violation involved. So that answers the question right there. This needs to be done in the open session. Okay, question number 17. City of Phoenix has a law that says it is unlawful for any person to obstruct any public street or alley or sidewalk. Some of our owners park on their driveway where the back end of the car is on the sidewalk. Are these homeowners in violation? Whose responsibility is it to enforce that law? City of Phoenix or our HOA? Probably the City of Phoenix would be, if you're trying to cite that law, you should contact the police and see if they'll do anything, or maybe even neighborhood services or code enforcement. If your HOA has something similar in the CC&Rs or the rules for your association, the association can enforce it too. Question 18, am I understanding that the executive meeting will reference firing of staff that needs to be announced at the board meeting? There have been a rash of firings that are quick, an hour notice to the person being fired, and the community never has heard anything in advance and is not able to get information after the firing. Okay, so this deals with how to, associations that might be firing staff, like let's say you have employees of your association. And I guess here's what I would say. As a business owner myself, and because I serve on a board, Sometimes you have information internally that, maybe the other residents don't know about. And like maybe somebody's falsifying their time card, or maybe they're stealing money, or maybe they're not showing up to work or whatever. And that may result in the board firing somebody, without a lot of notice. And, that's what you've hired. Basically, I mean, that's what you've elected these people to do. That's their responsibility. And some of this stuff can't be made public. So, sounds like you want more information on that. I'm sorry, you probably can't have it. If you, want to be more involved in the association, the way to do that would be to run for the board so that then you're in on the scoop on all of that. Question 19, our board has asked the board members to sign a code of ethics form. Should this be approved by the attorneys first, and is it legally required? So I like the idea of a code of conduct or code of ethics for a board that's dysfunctional and that's not functioning very well, has a lot of problems, confidentiality, maybe they don't get along. I think that's a very good idea. I do think your attorney should look at it just to make sure everything's okay and in compliance with the law. Is it legally required? No. But if a majority of the board adopts it, everybody's subject to it. Okay, question 20. Our board is meeting, all 3 members, for multiple sessions to discuss, interview, or choose a new community management company. Are we violating any laws? Okay, so it looks like you have a quorum of the board meeting to discuss, hiring a new management company. So you really should be doing it in an open board meeting. So if you're not doing that in an open board meeting and it's a quorum, you probably, are violating the open meeting law. So move that to the open session meeting to be in full compliance with the law. Next question, 21. How do we handle homeowner complaint about disturbing noise from their neighbor that keeps them awake at night? There's no reference to quiet hours in any of our documents. Tucson City Noise Ordinance prohibits loud noise between 10 p.m. and 7 a.m. The homeowner wants the board to solve the problem. The management company did send the neighbor a letter of complaint, but the problem is still persisting. What are the next steps? I mean, I don't know what exactly the noise is. Are they like jackhammering in their backyard, using a blowtorch? Is their dog barking? Are the kids having a wild party in the pool? I don't know exactly. First line of defense really should be that you contact the police for, noise situations. So that would be one recommendation. In terms of the board, there probably is something in your documents that requires, that owners not create a nuisance. So the board should continue sending letters to the owner, maybe even invite them to a meeting to talk about the issue. But ultimately, the police are going to be the ones that are going to help you solve this problem the fastest. So I would encourage you to encourage the owners to contact the police. Okay, next question, number 22. We reported an active roof leak 170 days ago. CC&R has determined the HOA is responsible for roof repair. HOA has delayed the repairs, and 2 weeks ago we got mold results stating we have multiple deadly toxic molds in our only bathroom from the roof leak. We won't have a bathroom for 8 to 10 days or 8 to 12 days during the repair. Would the HOA be responsible for alternative housing since the roof leak repair requires us to be out of the home? Yes, likely they will, and you'll just need to work with them to get that resolved. Question 23. Our HOA uses the personal information exception to talk about possible CC&R violations in a closed meeting. For example, they meet several times in a closed meeting to identify the homes that they thought needed to be painted. Now that I am a board member, I have seen the minutes and I can see that a lot was discussed in executive session and there was nothing about any particular homeowner's health or financial information. Was this an appropriate use of the personal information exception to open meetings? Honestly, I think it falls under, CC&R violations. I think it falls under a different section under the executive session exceptions. It falls probably under contemplated litigation. So under 33-1801 or 33-1248, it fell under that. So I don't really have an issue. I do not think it falls under personal information. So that's a quick answer to your question, but I think it falls under another one. So I wouldn't probably, go nutty on that because I think they did do it right. just the wrong exception, but they have the right to be in executive session. Question 24, can an annual meeting be conducted virtually? Yes, absolutely. The only thing that I will say about it, we talked a little bit about this when I was talking about annual meetings, is announce the procedure for the meeting at the beginning of the virtual meeting for the annual meeting. So like if the homeowner forum is going to be conducted at the beginning, make sure that people are allowed to talk then. And then if you're closing it during the annual meeting, let them know, hey, if you want to make a comment, you can do it to the chat function. And we have one board member that's reviewing the chat function, and we'll bring that, those comments to the forefront. Another thing is if people want to vote in person at a virtual meeting, the way we've done it before is to comply with the law, is we either have them text their ballot to the manager or the attorney or a board member so that it can be included in the count. Okay, question 25. Are HOAs required to have a board? So the short answer would be yes. One of our members hired a property management company to manage our payments. We have 5 members only in our community. They got a quorum due to 2 members not being eligible to vote due to late payments. This management company is calling themselves our board of directors. Shouldn't the owners be on the board of directors? I mean, I'd have to look at your bylaws, but generally speaking, yes, you should have owners running your board. Maybe you have a provision in your bylaws that allows non-owners to run the board. In that case, then I suppose the management company could appoint, themselves as the board, although not advisable. I guess the thing that I would be thinking about is, this is your investment and you want to make sure that, somebody who has an interest in the investment is operating as the board. So I would not be in favor of delegating this to the management company. I think you should have actual board members be owners. Number 26, I think you commented that decisions to hire and fire vendors must be done in an open session. Did I understand that correctly? Yes, I did say that. And if so, how do you handle performance reasons for dismissing a vendor that perhaps should remain confidential? I would just talk about those during the executive session. And I would say that we discussed extensively, there were some performance issues. And for these reasons, which we're not going to go into, in the open session, the vendor has been terminated, will be terminated by a vote. So I'm asking for a motion to terminate ABC Landscaping Company in second, and then maybe some short discussion and then vote, and it's over. It's in the open meeting. You can talk about the nitty gritty of the problems with the vendor in the executive session. You have the right to do that. You also have the right to do that in the open session. But most of the time, boards are doing this in the executive session. And then to actually fire them, you do that in the open session, or to hire them, that's in the open session because it doesn't fall under the categories of the closed session, executive session. So you got to do that in the open session. Okay, question 27. We have a small community of 36 condos. Rarely do members attend any meeting. Is a quorum for an annual meeting determined by the number of ballots received? Okay, so you have 36 units or condo. People aren't attending the meeting. That could be a good thing, because usually when people are happy, they're not attending, they're not making a big fuss. Is the quorum of the annual meeting determined by the number of ballots received? Yes, and you've got to look at your bylaws to determine what your quorum amount is. Okay, question 28. Looks like we have 1, 2, 3, 4, 5, 6, 7, 8 more questions, and then we're finished. I am a community manager for multiple boards. I have seen discussing items over emails to be a growing trend. I know in your presentation you discussed unanimous consent over email. Can you talk about discussing items over email as well? I did spend a little bit of time on this today, but I'm going to just kind of close the loop on this just to answer this question. So your board should not be discussing business via email, okay? It is contrary to the open meeting law. So the example I gave earlier was if a quorum of the board is, communicating by email, via reply all, and making decisions and discussing things, you're violating the open meeting law. Do not do that. The purpose of the open meeting law is to have discussion and votes at the open board meeting or an executive session. And if you are making votes by email and it's not an emergency circumstance, you are violating the open meeting law. It will catch up with you. Okay, so please be careful and don't do that. Question 29, what would you do about a board that has created a clique where they ignore willing volunteers for committees, but gaslight everyone by asking for volunteers and only choose volunteers that are members of their clique? What would I do about that board? Well, that's unfortunate, because really the reason why we get on the board is to help the community, and we don't get on it to be in a social clique or, whatever. So it's disappointing to hear that. I would try to get a seat on the board if I were you. I mean, I've been odd man out, odd female out, whatever on my board at different times. And, it's hard when you're not on the board and they're making decisions that are poor decisions. It's hard to see that because it's just painful. So the best way to handle that is to put your objections in writing and forward it to the board, and then run for the board yourself and try to make positive change from the inside. That's what I did, and I think it's worked. It's exhausting, but it does work. You just have to keep moving forward. Don't get involved in all the petty stuff. Get on the board and be professional. Next question, number 30 out of 35. The previous board chair had called 3 emergency meetings with no further information except to say it was personal to a homeowner. Should this information be in the minutes, and how would it be accessed by other HOA members? So I don't know what personal, I don't know how that would be categorized as an emergency meeting, but it just seems odd that you'd have 3. Maybe you'd have 1 if there was something really horrible that happened. And, we couldn't wait 48 hours to talk about it. So I guess, should this information be in the minutes? Yes, there should be emergency meeting minutes. So you could request to see those minutes. They may say it's an emergency executive session. And then you should say, well, what topic, was it in there? And they're going to say personal, right? And you're going to say, can I have more information? How do you define personal? They probably won't give it to you, but I will say this doesn't smell right to me. So I think if you're looking at this and thinking, this doesn't sound right, I agree with you. Okay, question 31. Our board president has created a Facebook page with our community page, but only approves certain community members to be a part of it. I'm seeing so many questions about boards behaving in a petty manner. Maybe that's a good topic for a class, right? I think maybe that's something we might need a refresher on, how that's so destructive and horrible for communities. Okay, but I digress. So you've got the board president running a Facebook page, not allowing certain members to be a part of it that are part of your community. This board president has also created a bunch of group chats with groups of 18 to 20 out of the 150 homes. Is this a violation of the open meeting laws? Based upon what you're telling me, I don't think so, because you haven't told me that there are board members on this and that they're discussing association business. So I'd say no, based upon what you've told me. Okay, 4 more questions. Our HOA number 32, our HOA management company says if we don't approve the assessment, we may end up in a receivership. What does that mean? Okay, really good question. That means things are really serious right now in your community. You don't have enough money to pay your bills. And so apparently there's an assessment vote that's going around your community right now. And if that is not approved, a likely outcome will be we won't have enough money to pay our bills for the community. And if that happens, somebody will petition the court to have a receiver appointed to run the business affairs of the association. And the first thing that the receiver will do after it's appointed is likely ask the court for special assessment, of the members to meet the expenses of the association, including the receivership fee. So, this is serious. What does this mean? It means somebody else is going to make decisions for your community and just start dictating this is how much is owed, and you need to pay it without any vote of the membership. So I think now's the time to roll up your sleeves and help out in your community and get involved, because it sounds like things aren't going well. And maybe this assessment really is needed to meet the expenses, and you should vote yes. And maybe you should be helping the board get the yes vote out, because if you don't, it's going to end up costing you a lot more money and you're losing control of probably the biggest asset that you have. Last 3 questions. The HOA number 33. The HOA held an emergency meeting for an issue in the community and provided notice that an emergency meeting was being held. The emergency meeting was about a year ago, and the minutes from that meeting have not been posted to date. Is this in violation of the open records law? If so, what is the appropriate course of action for the community members? I think what I would do is just ask for a copy of them. They don't have to post them anywhere. They're not required to do that. Ask them, hey, can I have a copy of those meeting minutes? And tell them, like under Arizona law, you were required to take those meeting minutes and see what they say. You also could ask for the meeting minutes for the meeting directly after the emergency meeting, because they should have read into the record more information at that board meeting directly after the emergency meeting. They should have read into the record the purpose, why it was called, what they discussed, and what happened at the emergency meeting. If they didn't do either of those, then you just let them know, like, hey, you need to go back and do that because you're in violation of the law. Okay, last two questions. If an outgoing board member does not have records backing up ARC and board decisions under their term that violates current association's documents, what action can the new board take to correct the violations? Okay, so you have a situation where you don't have good record keeping, right? And you don't have minutes, you don't have architectural approvals, and we've got some violations. So this is a really sticky wicket for the new board. I think you probably need to get your attorney involved to get some advice. And if you don't have the documentation on it, it's going to be really difficult to enforce some of these things. So talk with your attorney about it. Our firm's here, ready, willing, and able to help you if you want to reach out to us to talk about it. Last question for this morning. If an HOA has a 5 board member capacity, but presently there are only 3 active board members, what makes up a quorum? So you're supposed to, I'm guessing that 5 board member capacity means that you're supposed to have 5 board members, right? But you only have 3. So a quorum is 3. And you need all 3 of you to be at every meeting in order to conduct business. If you're in this situation, what I recommend is that you might also want to, start putting out communications to the membership saying, hey, we've got 2 vacancies on the board. Please consider joining our board. Okay, that's it for today. Just some concluding remarks. We had a really great turnout of people here today, 110 plus just live here right now. I'm not sure what the total was, but I think we were in the at least 120s, 130s today of people here today wanting to learn more to help their associations. So thank you everybody for being here today. Do not forget that, we had 150, I just heard, wowza. That's like pandemic levels. So great that we had so many people here today. Thanks for being here. Our next class is going to be our live virtual First Friday event. And that is always the first Friday of every month. In March, it's coming up like lightning fast. Okay, it's the first day of the month is March 1st. And it happens to be a First Friday. So on March 1st, at 9 a.m., we are going to be having our virtual First Friday event. And what that means is you can go to our website, sign up for it, submit a question, and join us on, virtually to hear me answer a whole bunch of questions on a lot of different topics. So hope you'll join us for that. Usually it's from about 9 to 10:30. We always get a great turnout for that. Our next class in March is our class number 3 of our 2024 virtual HOA Condo Academy, and that's going to be 2 days after St. Patrick's Day, which is one of my favorite holidays of the year, on March 19th at 11 a.m. And this is a really important class. We're going to be talking about how to turn challenges in your community into triumphs. We're going to give you some strategic solutions and suggestions for HOA and condo woes. So the big things. How do we turn things around when things are not going well in an association? Some examples would be aging infrastructure, not enough money, budget planning, what to do if you have fraud or embezzlement. Just really the big issues that keep board members up at night, and how do we turn it around so that things can, move in a more positive direction. We're going to be telling a lot of stories about problems that we've seen in associations and how they've successfully overcome it. It's going to be a great class, so I hope that you will join us for that class. That's it for today. Please consider leaving our firm a Google review. We're going to be sharing a chat on how to leave a review here shortly. We're always happy to get feedback from our valued customers, clients, and anybody who's participating in these classes, so we can continue to provide quality education programming and to improve our service. It's also really important that I'm able to provide the feedback to the neighborhood services departments who are sponsoring these classes so that they see that these classes are valuable and that you like them and you want more. Because of course they're always evaluating, are these classes successful and are they providing value to homeowners and board members and managers? So please help us out by doing that, leaving us a Google review on the link that we're providing. Thanks everybody for being here today, and I hope you have a great rest of the week and look forward to seeing you at future virtual classes, next one being on March 1st. Take care everybody. Have a great day.